The taking of evidence regulation. 1. Scope, purpose, and methodology. The regulation provides for the taking of evidence in another member state where this is necessary in civil and commercial proceedings. This concept should be interpreted autonomously in line with the other EU instruments in the EU Civil Justice Acquis. The court before which a case is heard in one member state can choose between two means of taking the evidence. It can either request the competent court of another member state to take the necessary evidence, or it can take evidence directly in another member state. The regulation is based on the principle of direct transmission between the courts, in which the requests for the taking of evidence are conveyed directly from the requesting court to the requested court. Each member state has drawn up a list of the courts competent to perform the taking of evidence according to the regulation. This list indicates also the territorial jurisdiction of those courts. In addition, each member state has designated a central body or bodies responsible for supplying information to the courts and seeking solutions to any difficulties arising in respect of a request. 2. Requests for the taking of evidence. The regulation lays down precise criteria regarding the form and content of the request and prescribes specific forms in the annex for making, acknowledging receipt of, the requesting of further information about, and the execution of the request. The requested court is to execute a request for the taking of evidence expeditiously and at the latest within 90 days of receipt. Where this is not possible, the requested court must inform the requesting court accordingly and state the reasons. 3. Refusal to execute a request. A request for the hearing of a witness shall not be executed when the person concerned claims the right to refuse to give evidence or is prohibited from giving it, either under the law of the member state of the requested court or under the law of the member state of the requesting court, and such right has been specified in the request, or, if need be, at the instance of the requested court, has been confirmed by the requesting court. Otherwise, a request for the taking of evidence may only be refused in a few exceptional circumstances. 4. Presence of parties and the requesting court at the taking of evidence. In its request for the taking of evidence, the requesting court has to state whether the parties to the proceedings and/or their representatives will be present or are requested to participate. The requested court shall inform the parties and any representatives of the date, time, and place for the evidence to be taken, and has to consider whether, and if so, under what conditions, the active participation sought can be allowed. It is also possible for representatives of the requesting court, including members of the judiciary, to attend when the evidence is taken, as well as to participate actively, if this latter is compatible with the internal law of the requested court and under conditions determined by that court. 5. Execution of the request. The requested court shall execute the request in accordance with the law of its member state. The taking of evidence can also be executed in accordance with a special procedure provided by the law of the member state of the requesting court, if the requesting court calls for this procedure. The requested court has to comply with such a requirement unless this procedure is incompatible with the law of its member state. 6. Use of communications technology. The regulation provides that the evidence may be taken through the use of communications technology, and in particular by use of teleconference and video conference. Again, if this is requested, the court must agree unless it is incompatible with the internal law of the requested court, or if there are major practical difficulties. Even if there is no access to the technical means referred to above in the requesting or in the requested court, such means may be made available by the courts by mutual agreement. 7. Direct taking of evidence. A request for the direct taking of evidence must be submitted to the central body or competent authority of the requested member state and can be refused only in exceptional circumstances. Direct taking of evidence may only take place where this can be performed on a voluntary basis without the need for coercive measures. Within 30 days of receiving the request, The central body or the competent authority of the requested member state shall inform the requesting court if the request is accepted and, if necessary, under what conditions according to the law of its member state the request is to be carried out. The evidence is to be taken by a member of the judicial personnel or by any other person such as a commissioner or an expert who has been designated in accordance with the law of the member state of the requesting court. 8. The costs of taking evidence. The execution of the request shall not give rise to a claim for any reimbursement of taxes or costs. Nevertheless, if the requested court so requires, the requesting court shall ensure the reimbursement, without delay, of certain costs as follows: fees paid to experts and interpreters, and the costs occasioned by the use of any special procedure for the taking of evidence requested by the requesting court. Only where expert evidence is to be taken may the requested court seek payment of an advance towards the costs of such evidence.